You know, this is a matter that you had already made a decision on the last time you were in court. I believe that if the state wants to reopen up this matter, and they are coming by way of an affidavit, they should seek leave of this court, first of all, to file in a further affidavit.
Mr. Better,
Yes.
my view then is that
Yes.
you respond after you have made submissions.
Yes.
Then you can select on that. All that is
Your Honor, what Mr. Cliff is trying to say that if they are allowed to argue the application, there is no application before. The question we are raising is just like a PO. Is there anything before you? So that once the court pronounces itself that there is a document before you competent to be submitted on, then they can submit.
But that can very well be part of the response. And the court will make a decision.
We are avoiding the question of content being submitted on. Then we respond on that content. We are simply seeking a procedural question. Once that procedural question is dealt with, then substance can proceed.
Raise your point, Mr. Better.
Yeah, please let them enjoy it.
You know, we were saying that a further affidavit in a matter that has already been determined by the court cannot be extended by a further affidavit. It does not have a life of its own. So the first thing they needed to do was to seek leave of this court, which they have not done. So from the word go, you need to stop them at this particular moment. Your Honor, the application, that the affidavit that is in court right now seeks to ask that the respondent hearing be held for a further 30 days.
And that is the problem.
Yes.
You want me to disregard that affidavit,
Yes.
yet you are referring to it. How do I do that without going into it?
Well, let us start by the issue that they do not have audience before you without seeking leave to file that correct.
Your Honor, to buttress our submission. Position of my learned senior, Mr. Cliff, or Mr. Ometa. Courts will only issue orders specifically prayed for the law of such orders is not in affidavit. An affidavit is evidence. A notice of motion needs to be in place. Supported with the grounds and a supporting affidavit. The law on miscellaneous applications is anchored on the civil procedure rules. It's nowhere in the Criminal Procedure Code. Therefore, this document is incompetent for this purpose as a document to be presented before court for the purpose of seeking orders. You know, secondly, the matter before you E075 is already determined. It can only be appealed against it cannot be made a subject of review now. When the timeline set by this court has elapsed. One will review sentence.
In 1 more minute, Mr. One more minute.
Yes. Oh, 1 more minute.
Yes.
Oh. Your Honor, one will only be allowed to review a sentence when it is running on, not when it is complete. The respondent was sentenced, if that is the right term, for 2 days, for 7 days, he has served. If they wanted to review that decision, it could be before the expiry of that term. Lastly, Your Honor, is that we completely object to such tactics by the state completely object to these tactics. I wouldn't want to talk about the content of it, but we vehemently object that let the respondent go home or a charge sheet to be produced before you. Mr. Soro has only one word.
Your name, give a name. The state has run out of ideas on how to punish the respondent. We came here.
Your Honor, we will object to that kind of language.
I am
I will not let it that go, Your Honor. That's it.
We can fight over this for hours.
We will fight.
And let me finish.
Your Honor, don't allow that kind of language to be used in the court.
Mr. Soro,
Let us be polite to one another.
is it okay? That's noted, Mr. Soro. Proceed.
Maybe Your Honor, then maybe let me paraphrase. The state has resorted to shifting goalposts. Your Honor, the ruling that was read by this one, the court on the 2nd of May has specifically order number 2, that this matter shall be mentioned on the 4th of May 2023 at 0900 hours for the state to appraise the court on the status of the investigations and for further orders. The court never asked for further affidavits. The status report of the investigations. You expected to come with the attachment or tell us that this is what we've done, or give us some evidence. We even support the malicious application to keep holding on the respondent. Such kinds of documents are what the Supreme Court called hot air. It is full of sound and fury signifying nothing. And this court has the powers to arrest such an injustice being perpetrated by the state. You want to arrest?
I want to say just one. Because you have heard the objections and my view they all have merit. Considering the time and the schedules and the need to move, I wanted to say to request and suggest, Your Honor, that you give us direction so that we proceed, so that Mr. Kiprop, though he really has nothing to say, but can say all of it, so that we don't make application, ask you to make a ruling, we come back again, because our interest now is that Ezekiel should not be in custody any longer. The more we take you around, we may end up keeping it long. I suggest that you direct in a manner that we proceed and finish up, and whatever, and you can even order the strike note or the affidavit, and Mr. Kiprop will say what you want to say, we reply, and we finish this.
Your Honor, if I may, with all due respect, we appreciate what the defense is saying. And we hear their various arguments. You have been invited to look at your ruling, which was delivered on 2nd of May, 2023. And particularly, you have been referred to the last paragraph in the ruling, which says that this matter shall be mentioned on the 4th of May 2023 at 0900 hours for the state to appraise the court on the status of the investigations and further orders. Your Honor, it is upon this subsection B of your ruling that we are before this court to appraise the court on the status of these investigations, and if there are any further orders that the court will grant, then we will make that application. I'm afraid that is what the learned senior Mr. Kiprop had started. That is the first thing that in his submission he stated, that the court had directed that we appraise it of the status of the investigations. That is when Your Honor invited the state and asked whether the application had been served. So I would agree that we can take directions based on Mr. Magolo's submissions. However, before the court does that, I will invite the court to consider two issues. Mr. Omari raised the question or the matters of civil procedure. This court is guided by the Criminal Procedure Code. And in any event, if the Criminal Procedure Code has not given express provisions on how this court is to be moved, which we are going to rely on C, where we were, one of the orders was to be at liberty to apply for any appropriate orders, which we are currently doing. Then the court is also invited to look at the Constitution, where the Criminal Procedure Code is silent on the way we are to move court. Under Article 159, Your Honor, if I may read Article 159, which I'm sure the defense counsels are well aware of, and the court. 159, sub-article 2D, that judicial authority is derived from the people and vests in the people by the courts and tribunals established under this Constitution. In exercising this authority, the courts and the tribunals shall be guided by the following principles. Now that moves me to sub-article D, that justice shall be administered without undue regard to procedural technicalities. Now, if the Criminal Procedure Code, which is the basis upon which we come to this court and has the procedures by which we are supposed to move this court, is silent on how we are to move this court, then I invite the court to refer to Article 159, which is the supreme law of the land. And basic law tells us that any other law which is inconsistent with it is repugnant to that extent of inconsistency. So, even as I rest,
1 more minute.
thank you. Even as I sit down, Your Honor, I invite the court to look at that provision in light of the submissions by the defense counsel.